Case during our January call will be People versus Lashawn Chatman.
Please proceed.
Good afternoon, Your Honors. Tim Baughman, Assistant Prosecuting Attorney, representing Kim Worthy, the Wayne County Prosecutor, and the people who are the appellant in this matter. In the Stevens case, this court said that a judge errs when he or she pierces the veil of judicial impartiality, and that the judge does so when, considering the totality of the circumstances, it is reasonably likely that the judge's conduct improperly influenced the jury by creating the appearance of partiality or advocacy against a party. And this court in this case has directed supplemental briefing as to whether or not the judge's questions in this case violate that standard. Added in this case is that, unlike Stevens, this is not a case of preserved claim of error, so this is viewed through the lens of plain error where Stevens was not. This court noted a number of factors that go into the inquiry in Stevens, including the nature of the judge's conduct, the tone and demeanor of the judge, the context of the issues and the evidence in the case, presence of any limiting instructions. And if one examines the cases in this area, both from the state and federally, there are more federally, I believe, as to what is it that characterizes questions that are viewed as showing bias or advocacy, I think you can see several things. One is timing. It's not the most critical, but the timing. When does this occur? In Stevens, the court noted that the judge intervened during the direct and cross-examination of a critical defense witness, the expert, and also of the defendant. The Court of Appeals here said that the judge here also intervened, but the judge didn't intervene. What the judge did here is allow the parties to have direct and cross, and if the judge had questions at the end, he was allowing the jurors to ask questions. First ask if the jurors had any questions, then ask any questions he had. So he did not interrupt, as happened in Stevens, and as happened in almost every case that you can find. Most critical is the content of the questions. As this court noted in Stevens, from the records, you don't necessarily know the tone and demeanor of the judge. Sometimes you can, but not always. So you look to the nature of the questions themselves, their content, and this court referred in Stevens to questions that exhibit hostility, bias, incredulity, disbelief, that are heated, intimidating, argumentative, put the witness on the defensive. Federal cases use the same language and also refer to it as the questions that's indicating skepticism. And I don't want to wish to belabor here this afternoon what I've said in our brief, and would invite the court to, again, I know it already has, review the questioning. The questions were not in any sense, as in Stevens, and in the cases that are cited in our brief, hostile or argumentative or incredulous or hostile or intimidating.
They were extensive.
They were, with regard to the complainant, they were fairly extensive. The judge basically covered a lot of the ground that had already been covered.
Yeah, I disagree with you. They were fairly one-sided. In other words, the judge wasn't supplementing the efforts of defense counsel in these questionings.
No, he really wasn't supplementing anybody's. He was simply seemed to be, and I'm not sure exactly how to put it, he seemed to be covering a lot of the same ground as though the examination hadn't happened.
Yeah, right, like as though the prosecutor wasn't doing his or her job, so the judge stepped in, right?
No, I don't think the judge stepped in. For whatever reason, the judge, I don't know if the judge, for his own purposes, judges have to make rulings on motions for a directed verdict and the like. If the judge thought he needed to clarify in his own mind what the testimony had been, it's hard to tell why the judge asked the questions. They seem to be largely pointless.
There was one point, well, pointless only from the standpoint that the prosecutor had already covered most of this, right?
Well, and had defense counsel. Defense counsel covered a lot of the same ground the prosecutor did.
Even at one point where the court was frustrated with a witness who wasn't able to connect the defendant to the fingerprints in the system, and the prosecutor said, oh, Judge, I see where you're going with this, I'll get to that on the next witness.
Yeah, and I think that, there you have an example of where the judge is trying to clarify. You've got the witness talking about a Ryan Reynolds in terms of the fingerprints from the gun.
I guess my point is, I don't disagree with you, the tone, and there's no interrupting, it's not what you typically see. But this is a sort of a very bizarre teaming up. I mean, doesn't it appear to be that the judge and the prosecutor are on the same team when the
No.
judge is trying to get inculpatory evidence out of a police witness and he's mad that he can't?
No.
He's frustrated, and the prosecutor has to step in and say, hey, Judge, go easy on our witness. We have another witness to satisfy that proof.
No, I think it's the judge in that case in particular trying to figure out, why is this evidence relevant? You're talking about a Ryan Reynolds, and the judge didn't understand he asked, is this a different person? Is Ryan Reynolds a different person? And the prosecutor finally understood what his concern was in trying to why is this relevant, to say, no, this will be connected up by a different witness. It's not error for the judge to ask a question in an attempt to clarify that brings out evidence that is harmful to one party or another. That is not, many cases say, that doesn't what shows bias. The judge's question may hurt a party by the answer. But the judge here, it was clear to me, and this is to me the most innocuous. He didn't understand why Ryan Reynolds was being talked about. Ryan Chatman is a different person?
I disagree that part in isolation was fairly innocuous. It just if I'm the jury and I'm watching the judge essentially repeat the prosecutor's case in chief, and then be frustrated when I can't get evidence I want, inculpatory evidence out of a certain witness, and the prosecutor even steps in and says, well, hold on, Judge, we're going to get to that next.
Well,
isn't there a danger that the jury sort of perceives the judge and the prosecutor on the same
there may
page?
be some danger, but I don't respectfully believe it's fair to characterize what the judge was doing as trying to get inculpatory evidence. The judge was trying to understand why this was relevant. Why is Ryan Reynolds relevant? Is this somebody different than Ryan Chatman?
Wasn't it evident inculpatory fingerprint evidence, and he was trying to connect
It was it tied the gun to the defendant, but the judge wanted to know why, if you're having a witness testify as to a fingerprint card with the Ryan Reynolds, is Ryan Chatman somebody else? Why is this relevant? And the prosecutor said, it'll become relevant. I'll tie that up with another witness. And again, it was about a matter that had nothing to do with the disputed issues in the case.
I've been involved in a fair number of trials myself, and something like this does occur, and the judge clears it up maybe with one question, and maybe even a question not in front of the jury. This, to me, is extraordinary. The judge goes through to this length, trying to get that information out of this witness, to the point that the prosecutor himself has to come to the rescue of his own witness.
I think my reading of it is the judge was confused. The judge didn't understand how the fingerprint with the SID cards could have multiple names.
I agree with you.
He was just confused.
I agree with confusion, but I would add frustrated.
He may have been frustrated, but he was trying to get to, why does this evidence matter? I mean, to clarify, why does this evidence matter? When the prosecutor said, that will be tied up, it was without any cross-examination because it went to an issue that was not a disputed issue in the case.
But he never says, how is this relevant? The question you want to ascribe to him. Instead, he keeps saying, does it match the defendant? You should tie it to the defendant. How can you tie this to the defendant? Over and over again, to the point where the prosecutor has to finally get up and say,
again,
no.
we may look at the evidence differently, but to me, the question differently. To me, the implication is, if this goes to somebody else, this doesn't mean anything in terms of this case. It doesn't tie the gun to the defendant. What are we talking? What's it coming in for? And the answer is, it's coming in. It's going to be connected later. It was connected later. The defense didn't even cross-examine. This was not an issue that the defendant had the gun and that he even hid the gun. He testified to all that. That was not an issue in the case. None of the things the judge went through with the detective or with the Pastor Fisher went to any of the disputed issues in the case, which were what happened in the kitchen. I'm not saying that the judge here should be applauded for this degree of questioning.
I understand.
I think judges can, in fact, not only ask unnecessary questions, but ask questions that may indicate bias that still doesn't meet the Stevens standard. If you look at the case cited by defendant, for example, a federal case, the judge said, the Castro case, the judge was found by the court to have interrupted the examination of the party in the case, it was a civil case, in a condescending manner, and at one point said, after she concluded her testimony, "That's it? That's your case?" And the court said, in the context of all the evidence, that shouldn't have said that, but it doesn't meet the test when you look at all the evidence. And the judge, if this court issues an opinion in this case, I think it would be appropriate to remind judges that the purpose of questioning is for clarification. And they really need, if they're doing it because they're not uncertain in their own mind, because they didn't pay attention, that's not a good thing. But the judges really do need to limit themselves to clarifying, and I wouldn't encourage judges to do what the judge did here. But does it meet the Stevens standard, and beyond that, is it plain error? I mean, you'd have to find not only that this amounts to error under Stevens, but that it was plain or obvious error that meets the Corinna's prejudice standard. I don't believe it's error at all. It's something the judge shouldn't be encouraged to do, but it doesn't show bias or advocacy. And if the court believes that it has some slight tendency to, it doesn't meet the standard of plain error. And it's not reasonably likely to have had the jury decide, well, as to the evidentiary dispute between the defendant and the complainant, the judge believes that the complainant's telling the truth, and therefore we should come out the same way.
Counselor, you don't think that has an effect? You don't think that when you kind of hear it from the judge and he's reiterating certain parts that are favorable to the prosecution, you don't think that that has an impact on how a jury sees it?
I think it's wholly speculative. The jury could sit there and think, why is he doing this? This guy is nuts. Or they could be bored. Or they could also think, why is he repeating this? He doesn't believe the witness. Say if this was done in cross of the defendant would be claiming that asking the questions again of the defendant shows that he doesn't believe the defendant.
Okay, but you don't think that in certain situations, you could argue that it ultimately creates almost a parental role between the judge and the jury, where the jury tends to bond with the judge, and in many situations that, jurors who, aren't as exposed to the legal process tend to seek approval from the judge that they're doing their job well or doing their job right, because they can't seek it from the other folks that are there. And you don't think that if the judge highlights, as in this case, the complainant was unarmed, and the defendant doesn't remember hitting him with a chair, and then the defendant struck the complainant or slapped the complainant. I mean, you don't think those are the kind of things that, like, if you hear those and they're all things that are put forth by the government, and it's put forth not by like an equal, like a litigant, but it's put forth by the judge, that it has a corresponding impact in terms of the jury's kind of interpretation of it?
I'm not sure how the judge could equalize it here. If the judge had asked the similar questions of the defendant, I think the claim would be that the judge was expressing disbelief in the defendant's testimony by going over it again. So in almost all of the cases you see, the problem is interjection during defense witnesses, as in Stevens, or the defendant, as in Stevens, not the questioning here that occurred with prosecution witnesses as to issues that were almost entirely undisputed. Now, you can make the argument that on the margins, might the judge, they bond with the judge, but the test here is it reasonably likely that the jury was led to believe that the judge thought the defendant was guilty, and under the standard of plain error. And I don't think this, maybe you'll have a case where a judge bolsters the prosecution evidence to a degree that you think the test is met. This isn't that case. There are no further questions. Thank you very much.
Mr. Baughman. Mr. Strauss.
Good afternoon, Gary Strauss on behalf of Mr. Chatman. I think the Court of Appeals did look at and was sensitive to the factors in Stevens, and they got it right in this case. I don't believe Stevens has any kind of bright line test as to whether there's hostility, whether you're interjecting with a defense witness. You got to look at the totality of the circumstances, which I think the court painstakingly did here, the majority. This was a 3-day trial, but basically a 1-day trial with the voir dire and the closing arguments. And the issue was Mr. Lawless's version of events versus my client's version of events. And not to rehash what the court, you're well aware of what the Chapman court stated, but what the judge did was just totally reinforce over and over again the prosecution's theory of the case. And as this court noted, the judge has an awesome power when he's up there, people listening to his every word. And as I prepared, I looked even closer at what the judge was stating, and sometimes it appeared that he made affirmative statements to the biggest issues in the case. When Mr. Lawless states that he was slapped, the judge stated, okay, and when he slapped you, what were you saying to him? That's an affirmative statement. And I don't want to be too nitpicky, but it's a very small trial here. Could have said, when you said that he slapped you, or when you represented that, but he says, you know, when you said he slapped you. As far as the chair goes, which was a big deal, because my client said they got into a fight over money and they shoved each other and he picked up a chair. He merely asked, do you remember picking up a chair? He said, no. But right before that, on cross-examination, his counsel, Chapman's counsel, said, so people told you that you threw a chair at Mr. Chapman? And he said, correct. They said I threw a chair. You don't recall that? No, because you don't have a very good memory of what happened, correct? He says, correct. So I bring that up because the judge just limited his questioning almost like a prosecutor. Really, he was better than the prosecutor. And he could have asked, but you don't really know what happened. You were a little inebriated. You know, cocaine in his system is, I think it was 3 times the legal limit or more, alcohol. So there were a lot of things. The judge amplified the case. He read what they said. He made affirmative statements for Mr. Chapman. And I think one of the problems is, as counsel brought up, you know, we don't know what the jury did. I think that is germane to the issue. When we have so many questions about how it affected the jury, there's a problem. And I think when Mr. Baughman was talking about sending a signal to judges, I think that's what this case does. It's a case-by-case determination, and when you have a short trial, certainly if you have a 3-week trial and the judge interjects once and there's incredible evidence, DNA evidence in a CSC case, that's one thing, but in this case it was uncalled for. The belligerence to the, with the SID numbers, in my mind, when I'm reading that, it's like, hey, this guy, besides being the only guy in the entire house that's armed and waving his gun around like a cowboy, and of course the judge had to ask him to stand up and show him how that was going down, he also you know, wanted to show, in my mind, that he used an alias. Here's this guy with a gun, only guy with a gun, he uses aliases. It was just tainted the jury to such a large extent that a new trial is warranted here. And I think the court made a real clear application of the Corinne's test. It looked over all the factors, totality of the circumstances. And I think Judge Godola's dissent really just did not appreciate the breadth of everything. Really didn't mention about the things I just mentioned about the chair and how he reiterated everything. He just looks at certain questions, reiteration of the people's case as being meaningless, but in this case, it certainly was not. Any questions? I hope so.
Do you think the Court of Appeals panel, the majority, correctly applied the standard of review?
Yes, for unpreserved constitutional error, the Corinne's sets forth that test, and they found that it interfered with substantial rights, fair trial in this case.
It was close enough.
Yeah.
Wasn't a very methodical application of the standard, was it?
Well, I believe so. I think the court really took great pains, the majority, to go through all the factors and explain the reasoning and how it did, you know, implicate the fairness of this trial.
Any further questions? Thank you very much, Mr. Strauss. Sometimes we're a little more quiet than at other times. Not very often, though. Well, we stand in adjournment until March. Thank you very much.